June 24, 1975. Appeal from District Court, Texas County, Merle Lansden, Trial Judge. Bank brought replevin action against appellee to recover possession of automobile pursuant to terms of security agreement. While action was pending, bank obtained possession of automobile, and it was sold. Trial court found bank was not entitled to possession of automobile, and appellee was entitled to recover its value. Jury returned verdict finding value to be $3,000. Trial court entered judgment for appellee for that amount, plus costs and attorney fees. Bank appeals. Affirmed. Lamar, Tryon, Sweet, Field Petty by Larry L. Field, Guyman, for appellant. Ogden, Ogden Board, Guyman, Benefield, Shelton, Lee Wilson Tyree by Jim W. Lee Charles the 50th, Freed, Oklahoma City, for appellee. Barry, Justice. This is appeal from trial court's judgment and replevin action. First National Bank of Amarillo filed replevin action against Robert the 50th, LaJoie appellee. It alleged right to possession of 1964 Chevrolet Corvette pursuant to terms of security agreement executed by appellee. While action was pending, bank acquired possession of Corvette and it was sold. Appellee filed answer and cross-petition alleging bank's security interest was void and requesting Corvette, or value thereof, be returned to him. After hearing bank's evidence, trial court found bank's security interest in Corvette was void under 14 AOS 1971 Section 2407, 14A 407, and appellee was entitled to recover its value. The question of value was submitted to jury, and it returned verdict for $3,000. Trial court entered judgment awarding appellee $3,000 plus costs and attorney fees. Bank appeals. Subject to exceptions not herein applicable, Section 2407, supra, prohibits seller in consumer credit sale from taking security interest in property other than property sold. It provides in part, 1. With respect to a consumer credit sale, a seller may take a security interest in the property sold, except as provided with respect to cross-collateral, Section 2408. A seller may not otherwise take a security interest in property of the buyer to secure the debt arising from a consumer credit sale. Message. 3. A security interest taken in violation of this section is void. Bank's evidence indicates its security interest arose out of transaction which occurred on November 24, 1972 in Amarillo, Texas, where an appellee purchased a 1973 Chevrolet Vega from Plains Chevrolet Plains. Plains and appellee executed instrument entitled Motor Vehicle Retail Installment Sales Contract in Security Agreement. Bank's name is printed at top of agreement form. However, form designates Plains as seller and appellee as purchaser. In agreement, appellee agreed to pay 36 monthly payments of $132.29 and granted Plains security interest in the Vega and Corvette to secure payment. Payments were payable at bank. The agreement contained provisions entitled Non-Recourse, Assignment, and Repurchase Agreement. On November 29, 1972, Plains executed these provisions assigning its right in contract and property described therein to bank. In repurchase agreement, Plains agreed to pay unpaid balance in event bank repossessed property and returned it to Plains. Bank's evidence indicates it buys thousands of contracts from Plains each year. When Plains salesman and customer agree upon credit sale, Plains credit manager calls bank, and bank checks purchaser's credit. Bank then telephones and states whether bank will give credit and conditions thereof. Purpose of this is to ensure bank will buy contract after Plains executes it. On this occasion, bank imposed requirement that appellee have larger down payment, additional collateral, or cosigner. Plains credit manager related this information to appellee and appellee offered Corvette as additional collateral. Parties then executed agreement and Plains sent papers to bank. Appellee has never been in bank, all papers were prepared at Plains, and contract was signed by Plains and appellee. However, appellee knew contract would be financed at bank. Bank subsequently repossessed the two automobiles and returned them to Plains. Plains paid bank pursuant to repurchase agreement. Bank also introduced financing statements executed by appellee as debtor and bank as secured party. These financing statements recognized bank had security interest in Vega and Corvette. After hearing bank's evidence, trial court found transaction between Plains and Appley constituted consumer credit sale as defined by 14 AOS 1971 Section 2 104, 14 A 2 104, that even